Recently, the Supreme Court of India gave a judgment clarifying the correct legal position regarding the property rights of Hindu Coparceners or Hindu daughters in coparcenary property in the light of the changes made in Hindu Succession Act 1956 by the central government in 2005. Many students and others asked this question, that is, whether it has changed the rights of the women, any new rights have been conferred. Does it mean that the clock can be turned back? What are the rights of my mother, my grandmother, my great grandmother in the joint family property or coparcenary property, so on and so forth? Here I would like to clarify one or two important things before I come to the analysis of the judgment in Vineeta Sharma versus Sharma, which was delivered in the second week of August. Property may be of two types. One is self-acquired property, which is earned by one self out of skill or whatever it is. The second one is ancestral property. This is what the Hindu law of succession recognizes. Ancestral property is the property which may come from the ancestors, like father, grandfather, great grandfather, so on and so forth. So, which may be inherited. Again, there are two things. Ancestral property could be either joint family property or coparcenary property. Coparcenary property. Joint family property is a bigger one. It may consist of any number of generations of people and it's a big unit. But within the joint family, there can be some small units called coparcenaries, which are recognized by both the major schools of Hindu law. One is Dayabaga school, which is followed in Bihar, Bengal and Orissa territories, and other one is Mitakshara school, which is followed by the rest of India, including South India, Telangana and all. And the question is this: there is no dispute about the property which is given under a will, that is testamentary succession. The law is equally applicable to the Hindus, the Christians, etc., depending on the provisions of Indian Succession Act 1925. So when somebody writes a will, to whom it can be given, or how it is given, how it is to be executed, what are the conditions, all those things are taken care of in the testamentary succession. We are not worried about it. Second one is the intestate succession, that is succession when no will is written by the common ancestor who is passing away. Then what happens? But anyway, first I will come to coparcenary. What is coparcenary? Coparcenary is something of an institution recognized in law which originally consisted of one common ancestor among the Hindus and three generations of male descendants. One common male ancestor plus three generations of descending males. Like, if P is the common ancestor, then his son, son's son, son's son's son. It may be in multiple numbers also. All of them constituted coparcenary. Initially, no women was a member of coparcenary. This was the real discrimination against the women. And as far as the Hindu women are concerned, before Hindu Succession Act 1956 was passed, Hindu women were entitled to two kinds of property. One, if they inherited property through ancestors, it was called women's estate. And this women's estate was under the Hindu Women's Right to Property Act, was a limited estate. Limited estate means, for example, through the husband, the wife got some property after the death of the husband. She was supposed to enjoy the property during her lifetime, movable or immovable, and enjoy the income arising out of the property. But she had no right to transfer the property. And after her death, the property went back to the legal heirs of the last full owner. Last full owner was husband, so husband's other male legal heirs. So they were waiting in line, you can say, for the death of this poor lady. So it was no property at all. Maybe sati and other things ultimately came into existence because of so many reasons, including this property reason. This was one. It was limited estate, life estate, limited ownership, by whichever name it is called. Then she had something else called Stridhana. Stridhana means, in fact, the gifts and other presents given at the time of marriage or at the time of farewell in marriage by close relatives like parents, friends and others, including movable and immovable property. This was her own property. She was the absolute owner of that property. And after her death, the property went to her own legal heirs, not the last, full owner's legal heirs. So not to the reversioners, that's what we say. Reversioners were not there in Sridhar. So this was the position before 1956 when Hindu law was codified. Then this discrimination against the women, especially against the daughters and all, was noticed in the Hindu Code Bill, ultimately by section 14 of the Hindu Succession Act 1956. They abolished limited estate. They said, if a Hindu woman is holding some property either by way of women's estate or Stridhana, whatever may be the mode, whatever may be the source, if she was in possession of property, she was enjoying that property, then she would become absolute owner in all respects from 1956 onwards. This is okay. Question is this: as far as the Hindu coparcenary is concerned, an exception was made. Hindu coparcenary property means the property belonging to this small group, I said, common ancestor who is male plus 3 generations of male descendants like son, son, son and son, son, son. It never permitted the women to make an entry into that. That means in that coparcenary property, whoever survived took the property by survivorship, and people got a share in the property just by taking birth in that particular family without doing anything. And the share of the coparcener fluctuated. If somebody died, the share of the existing coparceners increased. If a new person came, it got decreased. Likewise, women was nowhere. In the self-acquired property of father, mother, etc., women, the daughter always enjoyed equal rights on par with the sons. But in coparcenary property, she did not enjoy because of religious factors, other factors, because of unnecessary protectionism. That is a long story. Well, what happened in 1985 or so? N.T. Ramarao, a great champion of women's rights, he was the first chief minister in India to ensure that an amendment was made in Andhra Pradesh to recognize Hindu daughters also as coparceners in respect of rights as well as liabilities, both in the coparcenary. But certain other discrimination continued, like if it was a joint family property, then the daughter was supposed to wait till the partition took place at the behest of the sons. Similarly, certain widows, they lost their right to get the property once they got remarried. Except these 2 or 3 important points of discrimination, daughters and sons became equally, entitled as well as liable to rights and liabilities respectively from 1985 onwards. The AP amendment can be seen, 29 A, B, C, these 3 sections provided for that. He ensured that justice was done to the women to some extent. But similar thing also took place in other states like Maharashtra, West Bengal and Tamil Nadu. Succession is a concurrent subject. So central law can be there, state law can be there so far as there is no conflict is concerned. Be that as it may, then a central amendment took place in 2005, which is applicable to all the states throughout the territory of India. And this central amendment made in 2005 said that daughters also will become co-parceners everywhere, not necessarily in Andhra Pradesh, Karnataka, Telangana, whatever it is, right? And these daughters will continue to enjoy equal rights, but one condition is that if the co-parcenary property was not partitioned by a registered sale deed, or it was not willed away, means in respect of which will was written and executed, right? Or if it was not transferred or alienated or disposed of, means if it remained intact, undivided, unpartitioned, untransferred by 20th day of December 2004, then in such a property, Hindu daughters also will have equal shares like the sons. This was a very good move, and it also removed other discrimination, like they could seek partition of the dwelling house, and even if some widows got married subsequently, they also continue to have right to property in the property of the deceased husband, so on and so forth. This is one important aspect. Then, two important judgments were given in this context. One was in Prakash versus Poolvati case, 2016, where the Supreme Court held that if you analyze the 2005 amendment to Section 6 of the Hindu Succession Act, it will be only prospective in nature. That means they said that it will be, daughter will be a co-parcener on and from the commencement of Hindu Succession Amendment Act 2005. Means not before that. Not before that. This is one important aspect. Then another important aspect is that the one rule was that substantive law is always prospective and not retrospective. This is one important aspect. Okay. In another case, which was delivered in 2018, the Supreme Court, that is in the case of Danamma versus Amar, gave another conflicting verdict about retrospective nature. Is it prospective or retrospective? This is one important aspect. So one, Prakash versus Poolvati says it is prospective, Danamma says it is retrospective, and in fact the date of death of the father co-parcener also makes all the difference as per Prakash versus Poolvati case. Then in view of the conflicting judgments given in both the cases, the matter was referred to Vineeta Sharma versus Rakesh Sharma. That was the case, which was referred to a 3 judges bench of the Apex Court. And in its judgment dated 11th August 2020, that is last month, the Supreme Court held that Section 6 of the Hindu Succession Act confers equal status of co-parcener on all children, whether sons or daughters, irrespective of the time of birth, whether they are born before 2005 or after 2005, with same rights and liabilities, but condition is that the property should remain undivided, unpartitioned, or not transferred as mentioned before, that is before 20th day of December 2004. This is one important aspect. Then another important clarification given by the latest judgment is that whether the father co-parcener from whom the daughter is claiming the right is alive as on the commencement of this Act, Amendment Act 2005. In fact, people say that it's a substitution of the complete section, not amendment alone. And there are technical issues also, whether it is retrospective or retroactive. And the Supreme Court says it's retroactive, not retrospective in a way. But if the property remains undivided, unpartitioned, not transferred, even on that particular day or till today, whatever it is, daughters will get equal right. Of course, some people say that no, daughters will get right even in the self-acquired property or other property of the father. They will get their right as class 1 legal age. Class 1 in the schedule to Hindu Succession Act consists of number of ladies also, including daughters. So when they are getting there as class 1 legal age, why should they get double benefit as a co-parcener? But the Supreme Court says same benefit is given to the sons also. So nobody can say that the daughters are going to get double benefit. This is another important point. So what I am trying to tell you is that no major change has taken place. Events have not fallen down, and today the daughters stand on a better footing because of the irrelevance of the death of the father, time of death of the father. They will continue to have same rights but continue to be liable equally on par with the sons as co-parceners. What we have to understand is that the Hindu daughters at one point of time had no rights in respect of property. Then some right was recognized in the form of women's estate, Sridhana. Then in 1956, in self-acquired property, equal rights were given, but in co-parcenary property they were denied. Then in some states in 1985 or from 1985 onwards, they started getting equal rights on par with the sons. Other states also followed. Then came that Central Amendment 2005. Now everything is clarified. Maybe, and the Supreme Court also said, any matter which is pending before any court in respect of these issues or any appeals which are pending, now they have to be decided in terms of the judgment given by the Supreme Court. So, the daughters, if they can prove that the property is undivided, unpartitioned, unsold, still, jointly with the, in the name of father or whoever it is, they are going to get equal share. It may be a lawyer's paradise. A clever lawyer will definitely, invoke this particular judgment to ensure that the daughters get a better right. Those who have, already transferred or partitioned, they may be on a different footing. But the fact is that one unsettled question has been settled. This is first point. But Hindu family system has to be protected and preserved. The need of the hour is not litigation, but its mitigation. What we need is settlement of these disputes wherever it is possible, wherever it is feasible, both possibility and feasibility, in view of the cut-off date, the property remaining united, undivided and all. Then maybe ADR techniques can be used, maybe mediation centers can be asked to play their role. Then only probably the family system will be intact, the natural love and affection will retain their position, and gender justice also will be done. So as I already said, it's not the litigation but the mitigation of litigation which is need of the hour, of course without compromising on right to equality of the daughters. So the daughters can rejoice and they can claim their rightful share, but without permanently damaging the relations with their other family members. This is one small clarification which I wanted to give on the latest Supreme Court judgment. We shall meet in the next episode on another relevant topic. Until then, please take care, stay safe, and do subscribe to this channel.